I know part of it's just logistics. They're dealing with so many more people, but I just don't understand why it takes 4 hours to get a prospective juror into a courtroom. I don't understand that. And I hate it because it makes my job harder because so many people get where you're at and think, I don't want to be here, I don't want to be here, I don't want to be here because you've heard all the horror stories. All right, good morning, folks. Have a seat, have a seat. Look at how excited they all are to be here. That was something new called sarcasm. How many of you folks, seriously, how many of you folks were kind of looking forward to coming today? All right, that's unusual. Usually I get, yeah, there is one hand. You, reluctantly, right? Yeah, usually there's one, maybe two. How many of you folks, when you got your notice to be here today, thought things you wouldn't want little kids to hear? Now you're lying. Nobody was upset about jury duty today. Okay. How many of you folks have served on a jury somewhere? All right. Couple. Back row, man. Where at? Did you serve locally or downtown? Here? Okay. And once again, I want you to be honest with me, but it was a positive experience, wasn't it? Yeah. Okay. How about, sir? Where'd you serve? Downtown. Okay. Criminal or civil? Criminal. How long? 8 days. Okay. Not so positive, was it? Yeah, it's a big time suck. You lost money. Yeah. I have a friend of mine. I just talked to him last week. He went down. It was 4 hours before he made it to a courtroom. An hour of that was standing in the hallway. And he's a real easygoing guy. Not a positive experience. Although now they let you have your phone, so you can at least take care of some business and stuff like that. A couple hands over here. Who, sir, ma'am, where at? Detroit. Detroit. Criminal or civil? Criminal. How many days? 5. Yeah. Positive? All right. Okay. Yeah. Somebody else over here? Downtown. Criminal? Yeah. Okay. How many days? 2, not too bad. Okay, so here's the thing. I tell people all the time, some of you folks, well, all of you actually, you're all going to leave here at some point today, I promise you. Whether or not you serve or not, you're going to leave. And somebody's probably going to contact you, friends or family are going to probably contact you in the next month or 2, 3, whatever, and say, hey, I got a notice for jury duty. What do I do? Tell them if they got a notice for local, go with an open mind, serve. If you get a notice for downtown, take a good look, right? I mean, it is what it is. I don't understand. I really don't understand. I know part of it's just logistics. They're dealing with so many more people, but I just don't understand why it takes 4 hours to get a prospective juror into a courtroom. I don't understand that. And I hate it because it makes my job harder because so many people get where you're at and think, I don't want to be here, I don't want to be here, I don't want to be here because you've heard all the horror stories. All right, I can guarantee if you spend the day with us today, you will think it was more positive than negative. I can guarantee that. There's no doubt in my mind because I've talked to so many jurors after they've served, and I know my people. My staff understand that their job today is to make things as comfortable for you as we can because none of you really want to be here. Even the guy in the back that's like, yeah, maybe. And we also understand that we're asking you to come into a job that most of you, or probably none of you, have had any training to do, right? I mean, any lawyers, right? Paralegals, no. Yeah, so you don't even know our system, right? You don't even know the world you stepped in today. We know that can be uncomfortable for people, and we're asking you to do that job with people that you probably don't know. You put all that together, and it doesn't make a warm fuzzy when you walk in the door. So we recognize that. So you might have figured this out. I love this process because I get to talk to people that I don't get to see. Okay, I love this process, and I'm also a big fan of the jury system. I think our criminal justice system is a flawed system, but I also think it's the best one anybody's come up with yet. And I think this is part of that reason, the jury. You know, there are a lot of people in our 5 communities that think I'm a flaming idiot. Okay, so if one of those people get charged and end up in my courtroom, they shouldn't have to have me hear their case. They get to ask for you folks. Well, I hope Miss Evans doesn't think I'm an idiot. I hope that's not why she's having a jury trial. But that should be an option that folks who get charged with a crime have. Okay. I just think the system's a great system, even though it's flawed. And I thank you for making this part of the system possible today, because you showed up, even if you were reluctant, you showed up. So the way this works is my role is to make sure that whoever gets picked as an actual juror, when we send those folks in to deliberate, it's my job to make sure they've got the information they need. So the attorneys are going to provide evidence. I'm going to provide the rules, the law that you are to apply, and we're going to send you back into the jury room. I tell you this to tell you what's coming. The state of Michigan, in all of its wisdom, has 3 volumes of criminal jury instruction. Okay? Now, you're not getting all 3, don't panic. But part of the information, and much of the information you need to have today, is out of those 3 volumes. And I'm going to provide that to you. You don't have to go look at it on your phone during break. I'm going to give you the jury instructions you need to know. Some of them I'm going to give you more than once. You're going to hear them repeatedly. To do that, because we're not big dollars here. We don't have the teleprompters, so I can act like I'm looking at you when I'm really reading a screen. We don't do that like the politicians do. So I'm going to really read a screen. And I'm going to get ready to start doing some of that now. And that means you're going to look at my forehead, and you might have figured out I would rather interact with you this way. Now I'm going to interact with this way. So bear with me. Let's see. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us to choose a fair and impartial jury to hear the case. During jury selection, the lawyers and I will ask you questions. This is called the voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused from this particular case, even though you may be otherwise qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there's a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a peremptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I'll now ask you all to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. Right hands, please. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? Thank you, folks. Have a seat. So I told you who I am, and I've got the high dollar nameplate. Over here is Heather Moorefield. Heather is my secretary recorder. Her main job out here today is to make sure that everything that's said on my side of the bar, which is that half wall between us, everything that's said up here is accurately recorded in case there needs to be an appeal or there's a transcript necessary for some reason. I want you to understand that for a couple of reasons. First, if you're up here and somebody asks you a question, answer audibly. Don't head shake it, because she can't record a head shake. We might see an affirmative or a negative head shake, but she can't record it. So stick with the yeses and the nos. And by the way, I don't know is a perfectly legitimate answer to a question. The other reason I want you to understand that is if she gets more than one person speaking at the same time, both those voices are going into her headset. Both of those are being recorded, and it's a mess. So for example, if I ask you a question, just wait that extra pause or two to make sure I'm done before you start the answer, because we can't have people talking on top of each other. Officer Krolova is assigned to our courtroom today. Some of the other guys may be in and out. You know, if I give Joe a task and he's off doing something else. But the court officer's primary role is to make sure that things in the courtroom are safe. I don't expect that's a problem today. So his secondary function today, probably the most important one, is he's a conduit between you and me. So if, you know, we stick you in the jury room and I don't know, there's no water in the fridge or the temperature in the room is too cold or too hot or whatever, let Joe know. We're going to try to make things as comfortable for you as you can. So if you have any issues, let him know. Sometimes he falls asleep because he's been a cop for a long time, so he learned how to fall asleep while he was standing up. He usually doesn't, but generally speaking, he's keeping an eye on you folks in the jury. Okay, so if you need a break and you haven't caught my eye, just give him the mad eye until he acknowledges you, and we'll find out what's going on, and you can just say I need a break, right? Because we'll do that as well. I'm going to give the attorney the chance at this point to introduce themselves and any prospective witnesses by name at least. Ms. Manner.
Good morning, ladies and gentlemen. Good morning. Okay, you want to try it again? Good morning, ladies and gentlemen. Good morning. Awesome. I know you're all so excited to be here. But Judge Oak is going to make this fun for us. My name is Patricia Mandernick. I'm an assistant prosecuting attorney for Wayne County, and I represent the people of the state of Michigan today. I think this is going to be a quick day for you guys. I have one witness to present today. His name is Clayvon Evans. Does anyone know Mr. Clayvon Evans? Perfect. All right, I will turn you over to Fitz.
Now we get that practice. Good morning, everybody.
Good morning.
My name is Mike Kelly. I represent Lucille Evans. I work for a law firm, Kelly and Kelly PC. As the name suggests, a family firm. I only mention that because my sister is a divorce attorney, and if any of you may have had contact with her on either side, let me know if that name is familiar to Ryan Kelly. We only have to be dealing with this Kelly today. We may or may not hear from Lucille. I appreciate you guys all being here, and I hope that you pay attention and all judge's instruction. And it shouldn't be too long. Thanks.
All right, so you've already heard that this doesn't appear to be a long day. So any of you have any reason why you couldn't stick with us for what I would say at most a business day, 4 or 5 o'clock this afternoon? Any time constraints there? All right, how about health issues? I'm pretty loud. Anybody having trouble hearing me? Okay. If any of you, everybody's not as loud as me. Mr. Kelly, I was happy to hear you're pretty loud. If anybody's speaking, once again, on this side of that bar, from the witness chair or one of the attorneys, if you can't hear, just let us know. It's like I can't hear, and we'll move people around, or we'll ask people to speak up. How about physical issues? Anybody have trouble being seated for too long? Back issues, leg issues, anything like that? Awesome. Okay. All right. That's great. All right. So I mentioned something earlier about a break. One of the downsides or upsides maybe of our profession is we tend to be able to sit for long periods of time, and we sometimes forget that real people don't like to sit for 3 hours without moving. So if that's your situation and it's like, man, I just got to move. Once again, just let us know. It's like, can we have a break? And that's a good segue into this. Whether or not we take breaks, we're going to take breaks, because I can guarantee the process at certain times, we're going to have, the three of us are going to have to talk about stuff we don't want you to hear about, exchange recipes, whatever it is that we don't want you to know about. But other than that, if we break for lunch, that's going to be on you guys. So you decide if you want to break for lunch. You'll decide when we're going to break for lunch within reason. I mean, if you say we're going to break for lunch at 12 o'clock and we're almost done with a witness, I'm not going to say, okay, you just sit there. We're going to break for lunch now. But it sounds like this one's going to be fairly quick. So it sounds like we might be able to get this to final deliberations lunchtime-ish. So, right? Okay. So you might not want to break for lunch. You might want to just, drive on through and finish. But at any point, you guys are just like, hey, we need a break. Just let me know. We'll have that conversation. The attorneys and I will have a little group discussion. We'll figure out what we're going to do. Once again, I want to make sure that when you walk out of here, you can say, well, I don't want to do it again tomorrow, but it wasn't completely bad experience. All right, so let's move on with instructions. This is a criminal case. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges that the defendant, Lucille Evans, charges the defendant, Lucille Evans, with the crime of domestic violence, as reads as follows. The complaining witness says that on the date of February 7, 2024, at a location in Van Buren Township, the defendant, contrary to law, you don't have that in there. Oh, here it is. The contrary to law, did make an assault or an assault and battery upon Claiborne Evans, her spouse, contrary to Michigan compiled laws. This is a misdemeanor punishable by 93 up to 93 days and or $500. The defendant has pled not guilty to these charges. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and the jury can hear the charges. You must not think that it is evidence of her guilt or that she must be guilty because she has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that Ms. Evans is innocent. The presumption continues throughout the trial and entitles Ms. Evans to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances. Officer Crova, are you ready to pull names?
Yes, ma'am.
All right. Now, folks, Joe's going to call names, and he'll direct you where you're going to go. So, two things. Number one, if Joe mispronounces your name, the three of us are going to mispronounce your name every time we use it. So, if he does, please correct the pronunciation so we can all get it right. Number two, you're going to walk up between me and the witness stand here. There's an incline ramp there. It will trip you if you're not watching for it. And Joe and I will both try to remind you, but I'm giving you a blanket warning right now. Watch the incline ramp. With that, we're ready.
All right.